Hello, everyone. Thank you for being with us today for our probate seminar with Zach Beck. We are excited to learn about probate and what all it entails and just best practices. So, thank you, Zach, for being here. I do want to give a quick intro for Zach. He is with the Beck Law Firm, LLC, Peach State Wills and Trust. He's been with them since January 2023, focuses on estate and business planning matters and probate. He is a licensed to practice in all state courts in Georgia, as well as the U.S. District Court of the Northern District of Georgia. Earned his undergraduate degree in business administration at UGA, magna cum laude, and later earned his law degree at Georgia State University College of Law, a JD, magna cum laude. So go, Zach. Well done. He's married and lives in Decatur with his beautiful wife and loves to travel to new places. Went to Iceland for his honeymoon. I mean, that's incredible. That is an incredible experience. He's a runner. He does the Peachtree Road Race on the regular and just did the polar opposite Peachtree. Ran his first marathon at Walt Disney World in January 2026. So go, Zach.
Well,
That's
thank you to
exciting.
thank you to Neil for that introduction. Thank y'all for being here. I'm excited to talk through probate today and what it means for home sellers and buyers, and what y'all need to be aware of, how it may impact transactions, and how to prepare and best have things set up for an easy transition. Um, I
Fantastic.
th as go ahead.
I was going to say, as a realtor, I have run into situations where a spouse has passed away and we have to go through the probate process, even though a will was involved. And so I feel like that was one of the misconceptions that people definitely had, and I know you're going to address that, and just the timing of selling a house when it is going through probate or has to go through probate. So I'm glad you're going to be able to answer some of those questions, and we look forward to hearing what you have to say. So you can take the floor from here.
All right. Well, thank all of y'all for being here. Before I jump into anything, I have to give a standard lawyer disclaimer that the information in this presentation is for informational, educational purposes only. It should not be relied upon as legal advice. And while I am a lawyer, I am not anyone on this call's lawyer by virtue simply of being here. Before we'd have any kind of relationship, we'd have to sign an agreement documenting that. And now that all that legalese is out of the way, let's talk about probate. So what is it? What is probate? At its core, probate is simply the process by which we transfer title to assets from someone who has passed away to their beneficiaries or to their heirs. That process is court supervised. Every county here in Georgia has a probate court. And before that process can really get started, we have to appoint a representative of the estate called an administrator or an executor, depending on the kind of probate. There are different processes depending on whether a will exists or not. They're pretty similar in terms of what gets filed with the court, but they're different in terms of what powers a person may have, who gets the ultimate stuff, and things like that. So, in either case, whether there's a will or whether there's not a will, we got to go file a petition with the probate court where the person passed away. That petition's got to list out some information about that person and about their heirs. And heirs is a legal term. It's not who you want to get your stuff. They are defined by their relationship to you. For most people, if you're married and have kids, it is your spouse and your kids or descendants of deceased children. For people without spouses and kids, we start going out to more remote degrees of relation. We go to parents and siblings, nieces and nephews, and then start going out to grandparents, aunts and uncles, cousins, and beyond that. Certainly, your heir could be your 10th cousin twice removed, but that's likely not the case. In any event, we got to serve those heirs with notice of a petition, whether that's to probate a will or whether that's to have an administrator appointed to distribute assets. When there's a will, we give some information about the will. When there's not, we give some information about the assets. That gets filed with the court. After that gets filed, depending on the county we're in, we sit around and we wait a couple of weeks. Probate courts in a lot of the metro counties are busy. They get a lot of these petitions. And so we just won't hear anything. And it's not because they don't care. It's just because they don't have enough staff to deal with all of this. Once that gets entered, once the court looks at the petition, they typically enter an order that says, hey, yep, we're going to admit this will to probate, or we think this person could get letters. We may have to run some notices in the paper at that point to get powers for the person who's acting on behalf of the estate. The newspaper lobbies were quite strong when we vote our probate laws. And so every county legal organ makes some money when we do this. Notice will typically run for a couple of weeks for those powers. Then somebody goes, takes their oath with the court. We get letters issued for the estate. Then we run notice in the paper again for up to a month, asking about bills, asking about money owed to the deceased. And then that runs for 4 weeks. We then wait 3 months sitting around to see what bills come in. And so probate's not some scary word. It's not some overly complex process, but it is a process that even with a will here in a metro county will take at a minimum 7 months from start to finish. That doesn't mean, and we'll talk about this a little bit more later, doesn't mean a house can't be sold prior to the finish of that process, but certainly it is not a, hey, I want the house to sell tomorrow, I'm gonna go file the petition. That's just not something that can be done. That's not how our courts work here. Because of that, we're big here on probate avoidance. We're big here on how to keep things out of probate. That can be desirable to speed up the process of settling the estate, to make money and assets available quickly to loved ones, keep things out of court, and minimize potential challenges, potential, probate costs there that come up. And we'll talk more a little bit later about how we can keep those out, things to do to keep things out of probate. Some specific problems for home sellers, and Tennille, you hinted at this. Wills go through probate. There's this common misconception out there I see that people say, well, the will leaves me the house, so I get it and I own it. And that ultimately is true if that will is proven to be the true last will of the person who passed away, is admitted to probate in a probate court, if an executor is appointed, and if there aren't enough bills to require the sale of that home to pay off those bills and the creditors associated with it. Before any title to house can be transferred, we essentially have to have an executor or administrator appointed. We have to have some notices run in the paper, and then that executor, that administrator, would have to sign a deed conveying the property to the person who's supposed to get it, whether that's a family member, whether that's an end buyer through a sale transaction. Another really, really major misconception that we see out there is we'll see a couple, a husband and wife, two spouses, that think, well, both of our names are on that deed. We own the house jointly. That means that if one of us were to pass away, the other one just owns it. I can sell it. I can do whatever I want. That may be the case. It may not be the case. Here in Georgia, we've got two ways that individuals can own property jointly. One of them, called joint tenancy, avoids probate on the death of a joint owner and has that person's interest transferred to the other owners automatically outside of probate. The other option, what we call a tenancy in common, does not have that feature. When someone passes away as a tenant in common, their estate continues to own whatever share that they did. You've got to have a probate process, whether that's filing a will, whether that's petitioning for letters of administration, or some of the more rare probate processes to have that interest passed to heirs or to an end buyer. Tenancy in common is our default. If the deed doesn't expressly say that the people own it as joint tenants or as joint tenants with survivorship or jointly and upon the death of one of them to the survivor, then you don't have a joint tenancy. You've got a tenancy in common. For a lot of couples who may have bought homes prior to, there's no exact date on this, but definitely prior to the mid 1990s, and for some people as late as 2000, they may have a deed that's unknowingly tenants in common for whatever reason, despite joint tenancy having been a thing in this state since the mid 1970s. A lot of closing attorneys weren't defaulting to it, even for married couples, until right around 2000 or so. I get numerous cases, and I know, Tennille, you've had some clients as well, where the only thing that we've got to deal with in a probate case is a deceased spouse, half of a house. And that's an awful situation to be in. And so I'd advise anyone that, currently owns property with their spouse and is thinking, is this a problem for me? Go look at your deed. Look if it's got language that says jointly with survivorship or as joint tenants or joint tenants with survivorship. And if it doesn't, you can reach out to me or reach out to a real estate attorney, and we'd be happy to talk you through the process of getting that deed the way you want, making things simpler for you when one of y'all may pass away. Another kind of big problem that I see oftentimes is we get an executor appointed, we get an administrator appointed, and this person thinks, great, I can go sell the house. I'm all good to go. Not all administrators, not all executors, not all probates are created equal. Selling a house to an end buyer, so not distributing it according to the terms of the will, not distributing it to the heirs of an estate, but selling it to a third party is not a power that an executor or administrator has absent express language in a will stating that they have that power, or absent an order from the court granting them that power. And so if they don't have that power, then what you've got to do is go file a motion to sell property for a petition for leave to sell. Um, and that's not the worst thing in the world, but the problem with that is when we file a petition for leave to sell, you typically already have to have a contract in place. And so the seller will have to agree to a contract, and you've got to have a buyer who's willing to sit around for what may be a couple of weeks in some smaller counties or a couple of months in some metro counties, waiting on a probate court to say, yeah, I think selling the house for what it's worth is fair. And so if we don't have those powers, we're waiting around for the court to approve a sale. Your buyer may be sitting for a long time. Their mortgage lender may be getting itchy. The buyer may be getting itchy saying, well, I really wanted to move by this date. And the court is just sitting there going, well, your wishes aren't our timeline. We go when we want to. And so that can certainly add a lot of delays and unforeseen hiccups in terms of selling a property because that executor, that administrator may not know that they don't have powers until basically right when they're sitting at the closing table and the attorney goes, oh, you can't sell this. You've got to go to the court. This isn't specifically probate related, but it's something I think is also kind of important. Incapacity. So you also think, well, both of our names are on the deed. Yeah, my wife is kind of losing her mind. My husband, is no longer able to sign for himself. He's now in an assisted living and I'm taking care of things. Just because your name is on a deed doesn't mean that you have the unfettered right to sign for the other joint owners. If a person is incapacitated and they don't have a valid power of attorney signed by that or signed by them, designating somebody else to sign for them, then in order to sell or transfer their interest in that property, we've got to go to court. We've got to get a conservatorship, established and give someone that authority. There is no fast conservatorship. Those petitions take a while. There's a lot going on there. We'd have to prove to a court that person's incapacitated, can't act for themselves, get somebody appointed. And again, oftentimes in home sale contracts, time is of the essence. Whether that's an explicit term in the contract or not, people want to close by a certain date, having to then go and say, oh, we're going to have to sit and wait 3 months while the court appoints a conservator before we can sell you the other half of the house. That's not something that people are willing to wait for. And so certainly, having a power of attorney between, you and your spouse or you and someone you trust, so that if you are incapacitated, someone can act for you is certainly something we'd recommend that everybody have. Make things simple, keep things out of court, let things be done, as smoothly as possible. I've talked a decent bit about a lot of problems that come up with probate. Let's talk about some ways to keep things out of it. One way we can do that, having things in a trust. A revocable living trust is kind of the gold standard in probate avoidance. A trust is like a suitcase. It's a way that we pack your assets so that when you pass away or when you become incapacitated, we hand off that suitcase to the people that you've selected, the people that you trust, and say, here you go, manage this in accordance with the instructions I've given you. And so if we validly fund a trust, a house into a trust with a deed, then when someone passes away, their successor trustee, whoever that is, has full authority to sell it or distribute it in accordance with that trust's terms. We don't have to deal with any of the delays here in a Metro County probate court, and a sale can close relatively quickly. Without a trust, there are still ways to keep real estate out of probate to let things be a little bit simpler when somebody passes away. We mentioned joint tenancy with rights of survivorship as a way to own a house. That is a great tool for spouses, for long-term partners, to allow the house to transfer to the survivor of them when one of them passes away. You may say, well, shouldn't I just put my kids as joint tenants? Then the house goes to them automatically. And there's no probate, nothing like that. Doesn't that sound great? And yeah, keeping things out of probate sounds really nice. Um, but by putting your kids as a joint tenant on the house, you end up with some unexpected consequences. One, joint tenancy isn't just a when I die, this person gets the house. It would mean that your kid owns the house now, which means that they'd have to sign to sell it, which, if they're willing to, isn't the biggest deal in the world. But it also means that because they own the house now, their creditors can come after their interest in the house. And I don't know any parents out there that really, really want their kid's credit card company to come and take the house because they're irresponsible with money. And so, outside of spouses of long-term partners, joint tenancy isn't really a great tool to have houses avoid probate. You may ask, is there a way to do this without probate, but without putting my kids, I am on a joint tenant, or without going for a full-fledged trust? And that answer is yes, in some circumstances. Georgia in 2024, I was about to say last year, in July of 2 years ago, we passed a law that allows for what we call transfer on death deeds. These deeds allow you to name a beneficiary or beneficiaries on a house. You list out who you are, you list out who the beneficiaries are and where they live, you list out the legal description of the property, you sign it like a normal deed, you file it, you record it like a deed with the county, and then it sits there and it doesn't do anything. It doesn't transfer any interest in the property now while you're alive. If you later want to sell the house, if you move out, that deed just goes away because all it says is, when I die, whatever interest I have in my house goes to these people. If you don't own any interest in it, it can't transfer anything. When you pass away, the kids, whoever the beneficiaries are, whether that's a friend, a spouse, a child, grandchild, you know, whoever you want it to be, they've got some work to do. They've got to go file an affidavit within 9 months of your passing, stating some information, stating that the person who made the deed, the grantor, the owner of the house, they've passed away. That the person was named as a beneficiary on that deed. That you've got a copy of the death certificate, that you've got the legal description of the property attached, and for whatever reason, we have to make a statement as to whether or not the beneficiary and the grantor were married or not at the time of the grantor's death. As for why that's in there, your guess is as good as mine. It's in there. We file that affidavit, like a deed, into the land records within 9 months of that person's passing, and voila, the house gets transferred outside of probate to that beneficiary. Could be a great tool, but there are situations where it doesn't work. If you've got multiple intended beneficiaries. You got multiple kids or grandkids, and they don't see eye to eye on how things ought to happen. Not a great tool. Tennille, if one of the beneficiaries is really headstrong on, I want to hire Tennille to sell this house when I get it, and the other one is like, well, no, I want to hire Carice to do this. They've got to agree because they both own the house. And so if they can't agree, then we've just got them fighting. We're going to court. We got all these battles over what should be insignificant issues, but may not be to those people. And so if we don't think the kids will see eye to eye on, whether the house should get sold, who's going to be involved in that transaction, that deed, not a great tool. Also, not a great tool if the people you're thinking about leaving it to are minors. We can't leave a house, whether it's $100,000 house or $100 million house, to a 7-year old. That doesn't work. The 7-year old doesn't have the money, can't legally own the property anyway, can't own title in their own name, and so not a good tool there. And also not a good tool if, certainly you think one person wants to live in it potentially, and the others are just going to own a fraction and then get some money when it is eventually sold. That can kind of cause some family friction because you kind of got to agree on, well, does the one person owe the others rent? How long are they willing to kind of put up with you'll get your share when your brother is willing to move out? Things like that. And so it's a powerful tool. It's a great tool for a limited set of circumstances. I've done a number of them, but it's not, the end all be all. It's not some quick fix to the idea of keeping real estate out of probate. Um, Kind of the last big topic that I would say is if you have a will, and you think, I'm not going to do this TOD deed, I don't want to upgrade to a trust, make sure your will grants powers to the executor. Make sure that it's got a cite to the current statute is OCGA 53-12-261. If you've got an older will, it may say OCGA 53-12-232. If it doesn't cite either of those, make sure it's got something that says, my executor, my personal representative can sell property at a public or private sale without, obtaining court approval first. Um, if we got to go through probate, at least only having to file one petition saves us some time, some energy, some money, avoids some delays on the back end of having to have the buyer wait after we get a contract agreed to. Makes things a little bit simpler when somebody passes away. And those are, I would say, really the big things that come up in a home sale transaction that buyers and sellers need to know. Of course, there's a lot more involved in probate. We kind of skimmed through what that 6 to 8 month timeline looks like because a lot of it's not really relevant for a home buyer, for a home seller. It's a lot of doing some paperwork, running some notices, wait. And so, I want you to know about those delays, but certainly there's more involved in actually what you're doing during those delay periods. At this point, I'd open it up for questions, concerns, anything else that people want to talk about. Make sure we've addressed anyone's specific things so that y'all have the knowledge you need to move forward.
That is some excellent information, Zach. I took a lot of notes. I know Carice was writing away as well. Um, so I had a question about if the spouse is incapacitated, like
Yes.
losing their memory. You mentioned that that process takes a while, and I know the regular probate process you said take could take up to 7 months. So what's the timeline on that?
A conservatorship, honestly, is anybody's guess. Probates, at least, there's a probably less potential for disagreement because if there is no will, of course, there's no reason to fight about how assets get split. It's kind of set. If there's a will, oftentimes a lot of the family is on board. A conservatorship, could be quick, could be a couple of months, could be a very long time as people fight back and forth over who ought to be in charge of managing kind of the day-to-day financial activities of somebody. Um, all of y'all probably remember Britney Spears going crazy in the early 2000s.
Yes,
She had a conservatorship established. Her father
that's
was put in
right.
charge of her affairs. That litigation obviously spanned years. Now, of course, the conservatorship did get established. The litigation wasn't always about who should be in charge, but a fight over who should have kind of long-term financial custody over a person, there's no definitive or average
Okay.
timeline. It could take as long as it takes, depending on how much people want to fight.
Gotcha. Carice, what questions did you have? Or did you have
Let me
anything?
unmute. There we go. Okay. The transfer upon death, is that often referred to like as the Ladybird clause? Is that
So,
same?
no, a
Is that
ladybird
different?
deed is what we call a kind of an enhanced life estate deed. It
Okay.
is a form of a transfer on death deed. Georgia doesn't officially recognize ladybird deeds.
Okay.
We
That's what I was.
recognize what we call transfer on death deeds. Um, a ladybird effectively says, I convey this to me for life, and then at my death to this person. But it
Okay.
also then isn't construed as creating a life estate or a vested interest. It's also revocable.
It's also revocable as
But
well.
so Georgia
Okay.
doesn't recognize those.
Florida does though,
We skipped
correct?
over potentially as an
I
only
think,
Georgia licensed attorney. That's not something I can comment
yeah.
on.
I had one of my clients, she was discussing this with me and the fact she's an only child, so her
Yeah.
mother has this in effect for and has set up, a transfer on death, which but you were saying that there was work to do at that point. Is that, I mean, that's obviously something that her mother could gather that information and have it prepared so that when something,
And so, if this property's in Florida and if it's a ladybird, there may not be work for her to do. Georgia's transfer on death statute does
uh-huh,
say, hey, if we do one of these to claim the property, you've
uh-huh,
got to file an affidavit within 9 months of that person's
okay,
passing.
okay.
Um, there's not much that the grantor can really gather up to help that
Mhm.
person out
Well, that's
because, of
true.
course, she can't get her death
That
certificate while
certificate
she's
and all of
alive.
that. Mhm.
She can't well, I guess she could say, hey, remember, you and I aren't married. But we would hope that the grantee
Right.
kind of knows that. Um, we talked about kind of that 9 months clock. That is a strict clock. If
Okay.
that affidavit is not filed within 9 months, the property reverts to the probate estate.
To the
We've got to
probate.
open a probate to deal with that. And
Okay.
so certainly, like I said, TOD deeds, great tool for certain circumstances. An only child, often a great tool.
Right.
But
Right.
maybe not, always the best for anyone's circumstances out there.
Okay.
That's good.
Yeah.
Well, this has been extremely helpful, Zach. Can you tell us the best contact information for you if anyone needs to follow up with you or if they want your help in the future with
Yeah,
probate issues or just direction? What's the
yeah.
best contact information for you?
So,
It-
you can find our website at www.peachstatewills.com. If you prefer to submit online inquiries, there's a form there to reach out to me online. If you like talking on the phone, and there are people that do and there are people that don't, you can reach our office at 678-344-5342. You can speak with me. You might get my assistant Kalia. You might get our other attorney Joel. But any of us would be happy to talk to you, give you some advice on how we think you could set things
Mhm.
up to do better, and move forward with the representation as may be needed.
Mhm.
That's fantastic. Well, we will definitely be putting this video on social media so more people can hear about it, and we'll include it in the February newsletter. And we also want to thank you for coming back in February. February 20th, we'll do a Wills and Trust seminar. Zach will give us his expertise in that area as well. So I think people are going to get a lot of good information and have some good steps to take to make sure they are doing the right things.
Mhm.
Absolutely. Absolutely.
Mhm.
Looking forward to it, and certainly, happy to talk through all those as well.
Well, thank you, Zach, for your
Thank
time.
you.
Thank you, Carice, for being here.
Yeah.
Um, and y'all have an amazing day, and we'll talk to you soon.
All
Y'all
right. Thank
too.
you.
Thank y'all.
Bye.